And I guess, what I would say about the title is, if I need the appropriate cautionary language, it's forward-looking statements. And so we want to fall within that safe harbor. But it is an absolutely fabulous group of you. Thank you so much for joining us today. It's nice to see not just names, but faces of so many people that I feel like I haven't seen in months. So I'm really delighted that you all could be here. I want to welcome you on behalf of Penn Law. I want to welcome you on behalf of my colleagues at the Institute for Law and Economics. I want to acknowledge faculty co-director Elizabeth Pullman, who's here with us, executive director Larry Hammermesh, and managing director Nadia Janetta. I'm delighted to be here and to have the opportunity to have a fireside chat with Leo E. Strine Jr. Leo, of course, needs no introduction, but I'm going to go ahead and give him one anyway. Leo, as you know, is of counsel in the corporate department at Wachtell, Lipton, Rosen, and Katz. Prior to joining the firm, he was Chief Justice of the Delaware Supreme Court. And if I've got the dates right, that was from early 2014 through late 2019. Before that, he was on the Court of Chancery as Chancellor since June of 2011 and as Vice Chancellor since November of 1998. In those various positions, Leo authored many of the foundational decisions of corporate law, decisions with which our students are well acquainted. He's also been a longtime and beloved professor here at Penn Law. His course on great cases in modern Delaware corporate law, which he co-taught with Michael Wachter and Larry Hammermesh, has been one of the jewels of our business law curriculum. He currently serves as the Michael L. Wachter Distinguished Fellow in Law and Policy at UPenn, and he's been active in ILE. He's been heavily involved in our programming, and he's a valued member of our Board of Advisors. Leo is also, and I have to say this just sort of for equal time, he's also the Ira M. Milstein Distinguished Senior Fellow at the Milstein Center at Columbia Law School, and is a Senior Fellow of the Harvard Program on Corporate Governance. Leo served as special judicial consultant to the ABA's Committee on Corporate Law and the ABA's Committee on Mergers and Acquisitions. He's a member of the ALI, and he currently serves as an advisor on the new Restatement of Corporate Law project. And I'm excited to be working with him on that project because I am an associate reporter. So we've already, I think, sparred just a couple of times, and the project's only just getting started. He's also one of the most prolific authors in corporate law. If you weren't paying careful attention, you might have gotten confused. You might have thought that Leo was a full-time faculty member as opposed to all of those other things that I've just been talking about. Just a little bit more background. Before becoming a judge, Leo served as counsel and policy director to Governor Thomas R. Carper, and he was a corporate litigator at Skadden Arps. We're very proud at Penn Law to claim him as one of our own. He graduated magna cum laude from the law school here and summa cum laude from University of Delaware. Before we get started, just a couple of administrative matters. First of all, there will be CLE code words for those of you who are seeking CLE. There will be 2 code words that I will interject at appropriate points during this program. And second, I know it's a big group, but I welcome you getting involved. I'm going to try and monitor the chat during the course of the program. And so if you've got questions or comments, feel free to interject in the chat, and we'll see if we can get them into the conversation. And hopefully we'll have a little bit of time for Q&A at the end of the program as well. So with that, Leo, once again, welcome. Thanks for taking the time to talk with us today. We've identified a number of topics to discuss, but let me start you off by asking you to focus on developments in M&A and deal architecture. So it's been a crazy, 11 months at this point in the world. There have been so many developments. Ted talked about the pandemic. We've obviously had the horrendous incidents involving George Floyd and many others, and the attention that they have focused on racial diversity. And of course, we've had the change in administration. These developments and others have had a huge impact on corporate law. So let me start off by asking you about the pandemic and its effects on M&A, particularly developments relating to the definition of MAE and to operating covenants.
Thanks, Jill, and it's good to be with you. And I wanted with doing a program with such a distinguished security law professor, and knowing that we've got plaintiffs lawyers like Joel Friedlander and Mark Lebovich in the audience, I wanted to make sure that there was no lack of truth in advertising. So I am actually next to a fireplace, and I can light it, but I it's a kind of warm day, but I'm at least next to a fireplace, and it's an honor also to see so many of my judicial colleagues. And I think we have almost an on bank of people, of our friends from the Supreme Court. And I just, so great to see your friends, and including one of my great classmates, Justice Valahura, who we had as our dean, Bob Mundheim. So it's special to be with you all. And I think Jill put it rightly. Jill, I want to frame a little bit. These are kind of our prognostications we're going to kick around, and we want to kick around with you. They're not necessarily things that will come true, but maybe some things to keep an eye on. And in deal architecture, I think a few things happened last year that are putting a point on changes and forcing practitioners to think about how to draft until, to be honest, until some of the case law gets resolved at the appellate level coming forward. One of the things that everybody knows is that, or not everybody, but everybody on this program knows, is that when you started at the beginning of the century, material adverse effect pretty much meant material adverse effect. And it was a very open-ended concept, and it dealt with things that you couldn't specify. And classic things were like a missile strike or a hurricane. As we had experience with that, for example, IBB Tyson, things like Hexion, practitioners started to put in place exclusions. And for example, during the financial crisis, the reason why the MAC clause couldn't be used in a lot of deals was not because of the case law. It was because if you excluded an event that hit the entire economy, and the entire economy was suffering, it was very difficult to prove a MAC. If it was an industry thing and it was a financial deal, that would make that difficult for the buyer to use. As we got into the pandemic year, those exclusions had become, pretty ubiquitous. But one of the interesting things, I think, in terms of the architecture, Jill, that had not evolved was, what exactly is the definition of industry? Which is, even if you have an exclusion, you have the ability often to show that you've suffered a company-specific material adverse effect, and that you've been hurt in a disproportionate way compared to others in the industry, and therefore the buyer can walk away. Well, typically the architecture was to just use the term industry. And I was involved in a case in Michigan, actually, the Taubman case, where it never went to trial. And if we were in Delaware, I think would have gone much faster and would have less of a discount. But the issue in that case, Taubman operates very high-end malls like the Short Hills Mall, doesn't own really anything but malls. But the argument with the term industry by the buyer was that the industry was the REIT industry. And basically, as broad an industry as they could create is any REIT that leased real estate for any commercial purpose. So that meant if you had somebody who owned parcels where there were, because I'm thinking about Popeyes a lot because they've got a good product for Lent now. They've got a Cajun flounder sandwich for any else of Catholic origin. So you can check it out on a Friday. But if you think about a property that just has a Wendy's or a Popeyes on it, or a convenience store, they were trying to argue, Jill, that Taubman's was in that industry, and making the argument that Taubman was suffering disproportionately because REITs that rented to convenience stores, grocery stores that were open during the pandemic were suffering less than malls. So you're starting to see architecture, again, where there's definition of industry, because this also was a big issue in a case in the UK called Travelport, involving a business that really specialized in travel, but the buyer argued that it was really a part of an overall credit card industry. So I've seen a deal, for example, where it was an energy deal, and the buyer was a nationwide, Jill, energy player. The seller was really concentrated in the Permian Basin, which I understand energy people know about. I've never been to that basin, but but the seller's industry was specifically defined with relationship to the Permian Basin, and the buyer had a nationwide thing. So that you see the development now of more intricate architecture around industry. I'm not sure that's necessarily a good thing, but it's coming out of the pandemic. The other thing is, and this is an open issue in Delaware that I think people have got to think about, is the respective role of the operating covenants and MAE clauses. And it's very traditionally, to give an example, to go back to the MAE example, many of us were taught as young lawyers for books like Jim Freund's book or others, that a great example of an MAE clause is a storm or a missile strike or something that hits the company's only manufacturing plant. Well, we had some cases that are kind of analogous to that. But imagine that the MAE clause very clearly says that whatever hit that plant, if it was a storm or it was a missile strike, is excluded from being a material adverse effect. But the agreement says that the buyer has to operate in ordinary course. And it's the only manufacturing plant. Despite the clear allocation of risks to the buyer, can the seller claim, can the risk to the buyer, can the buyer then say, well, seller, yeah, there's no material adverse effect because we accepted the risk of a missile strike or a hurricane hitting that plant, but you can't run the plant, and therefore that's not in ordinary course. Now that sounds extreme, except there's a case right now in Delaware, again, I'm not going to comment on it, but where that's very much in play, because the MAC clause was found to allocate the risk of the pandemic and its effect on the seller's business in terms of having to restrict the operations of its business. And so the buyer didn't win on the MAC clause, but because the seller had to react to the pandemic, then it was held to breach ordinary course because it had restricted the operations. And I think there's a lot of interesting play around this right now, Jill, in terms of how people think about these, because I believe most people thought that the MAE clause and the covenants need to be read together, and that the ordinary course covenant really didn't mean that you couldn't adjust to external circumstances. It meant you couldn't make a profound change in strategic direction on your own instance, which these companies weren't doing. They were just trying to weather something. Or you couldn't engage in something like a special bonus or dividend that was an asset strip between signing and closing. And it also is interesting because there's a clash of covenants in this architecture, because there's typically a covenant that you have to comply with the law. And many of the businesses during this time, the restrictions on their operations were either mandated by law or done in close anticipation of legal shutdowns. And there's also usually a covenant that you have an active duty to preserve value. And so there's a lot of flux right now around the architecture, because folks are worried that the traditional role of covenants versus the MAE condition has been unsettled. And people are now starting to write ordinary course provisions that have MAE-like exclusions. And count me, just as someone was a judge for 21 years, skeptical that the more words you necessarily use in contracts, the more predictable it gets. And that if you're now having the interplay of the exceptions in the MAE clause come together with the exceptions to the covenants, I'm not sure we get more coherence, but it's understandable that that's what parties are doing right now. And so I think if you look at deals, and many of you know this better than me, are watching them. I see my friend George Casey here. But I think if you're involved in deals now, there is a lot of discussion around the covenants that there would not have been several years ago. And so, these things continue to evolve. And there's also another thing I would say in praise of Delaware, which is, even though some of the Delaware decisions have caused some of the concern, the Delaware courts really are to be applauded in a huge way for stepping up during the pandemic in these expedited cases. Many of the cases that were outside of Delaware, like the UK case I referred to and the Michigan case, were profoundly influenced by the lack of availability of a prompt forum. And that, by definition, I think anybody would tell you, gives the buyer leverage. If the seller can't at least get a prompt hearing, and the seller and the buyer doesn't face the possibility of a specific performance remedy or some remedy, then you can almost always get a discount. And even in Delaware with the prompt thing, there were some discounts taken just because of the natural leverage of it. But I really do applaud the Delaware judiciary for stepping up at this difficult time. And I would say that choice of forum, to the extent you have it, and making sure that if you're on the sell side, you can have a forum like the state of Delaware, which will allow you to get before the court if you need to enforce the deal, is really important, Jill. And I think some of the lessons out of the year will just emphasize that.
Yeah, I'm glad you made that last point, because one of the things that I was going to observe is we've gotten an awful lot of guidance during this period of, varying levels of lockdown from the Delaware courts, right? A completely unpredictable, unforeseen event happens, affects the capital markets, affects a variety of businesses in different ways. Who knows what the impact is on all of these pending deals? And what you see, from the beginning is the Delaware courts weighing in and giving the parties the tools they need to, cope with the situation. It really is quite remarkable. What I wanted to follow up on a little bit is, what you described with respect to the operating covenants and the sort of complexity that we've seen in that area is something that we've seen for a number of years with respect to MAC clauses. And on the one hand, if you're a sort of contract person, you say this is great. Parties can negotiate, parties can make the terms clear, they can allocate risks, and so forth. But on the other hand, there's the problem of increased length and increased complexity. And at the end of the day, do people really have a better sense of what their rights are?
No, and I think one of the concerns here is I think that there'd been a fairly robust movement towards the following allocation of risk. Systemic risks, economy-wide risks, industry-wide risks were going to be borne by buyers. Buyers would have to accept that to tie up the seller. And because the seller is tied down, and with the regulatory dynamic, some of which we'll talk about, the regulatory dynamic around deals became very unpredictable and complex during the Trump years. That puts sellers more, you're basically capped at the deal and you're constrained. The idea of the industry test against the industry or the economy is if you can show we had a company specific impact, like the Acorn case was, many of us on the court were involved in that. And it was a very clear case. I mean, this company just, unfortunately for it, the seller just sucked in comparison, to use the technical term, by any measure. It wasn't even close. But the idea of this was to make the MAC clauses harder for a buyer to use, and for the buyer to have to show that something specific happened to that seller. The problem with ordinary course using it in this way is if everyone has to shut down because of the pandemic, and by just shutting down, you're violating ordinary course, even though the risk of what caused that has been shifted to the buyer. I mean, I don't think it was any responsibility of drafters to anticipate that kind of construction. And they didn't. But now, because they've seen it, it happen, they're having to write ornate on ornate. And, and there's even existing with these exclusions. I think, to be honest, I think you have to go right to the exclusion to sensibly interpret these things. And what I mean by that is you go right to the industry comparison if that's what they're arguing. But that's not the way all courts have done it. And these things get kind of head hurting. And I think the more, Jill, that you write the ornate on top of that covenant, you're talking about what is, again, the law compliance covenant was huge here. There was a clash of covenants in almost every deal. And you had a duty. And so the idea that you would be, that an agreement, you couldn't comply with the agreement, which in some ways is some of the buyer's arguments, that the seller was just, if the seller opened in defiance of the law or put people at hazard, that violated the law covenant. But if they closed in accordance with the proper procedures and industry standards, that they violated the other covenant. And so the buyer got to walk, even though the MAC clause clearly allocated the risk of a pandemic to them. That just don't make, I'm just saying, I think sometimes there's a tendency for judges to say, well, people can write around a problem. But I think most of us in Delaware have always tried to take, we don't want to create the problem. I mean, sometimes it's the lack of understanding of how the architecture works, that creates the problem. And then it's not that anybody failed to anticipate it. It's that the judicial ruling itself was unexpected. And then people have to react and write around it. And I think that's an open discussion right now around some of this architecture.
I think that's a really important point, and I think it's something we've got to keep in mind that even though in theory we can draft around or we can accommodate a lot of the developments in the law, that might not be the most efficient approach going forward. I want to interrupt myself to interject the first CLE word here. The first CLE word is chancery. So for those of you who are getting CLE, that's chancery.
I can guess the next word.
I bet you can. I try to make it really hard.
Yes, because Jill will not leave any of our friends out, so I know the next word.
Well, I'm going to have to, because actually we've got a broader range of judicial representation here than I can accommodate with just 2 CLE words.
Okay. Oh, great. That's better.
But let me move you on, because I know our time is limited, to a somewhat related issue. And that is the impact of the pandemic on the Revlon doctrine. And a couple of things going on here. One, a lot of the companies that are involved or potentially can be involved in the deal space may be companies that have accepted pandemic funding. And 2, there's this whole stakeholder capitalism movement that you've written about fairly extensively. And I don't want to sort of get into the weeds on that, or at least get into the weeds quite yet. But how did those factors influence? How do they impact the Delaware court's traditional Revlon analysis? And is this kind of going to put strain on Delaware's ability to adhere to Revlon, increasingly sort of distancing, I think, Delaware doctrine from a lot of the popular movement?
No, I think it's a really interesting issue. And for this reason, I think, is if you think about how many companies took governmental assistance last year, it's a huge sector of the economy that got a lot of assistance. And honestly, you can't exclude what the Federal Reserve did as well to prop up the economy. That was done in many ways to protect the employees of companies and the communities in which companies operated. And that comes on top of, frankly, we know that, famously, for example, Amazon did their search for headquarters. Very few plants in the United States or facilities in the United States have been located or expanded with a company paying its full school taxes or property taxes. They almost always seek subsidies. So you have beat up companies, and part of why everybody was, there was a little bit of a dampening on activism and on acquisitions in the beat up company space because of valuations. Joe, what I've got my eye on is the following. You've got companies that still are not in robust health because we still are, there's we can talk all day about the bizarre world we're in between the financial economy and the boom years some of our law firms had and how busy the Delaware firms are and the real economy. But there's a real gap there. And so there's a lot of businesses suffering. Was a unique thing that many of our investment banker friends and transactional lawyers know on the phone. There's private equity did some unusual investments. I see Bob Friedman there last year. There were some unusual investments where private equity basically did a 5 to 10% stake in a company and don't have a controlling stake, didn't take it private at that time, but have a fairly influential position. You can imagine that we're going to have situations where some of these companies are in industries that may need to consolidate as a result of the pandemic. And so that raises the issue of two strategics, perhaps combining, Jill, both of whom receive government assistance. And what are the guarantees for the workers and communities who are supposed to be the objects of, that beneficence? What protections are there going to be? And so then the whole concern about private equity, of course, is that, and we can talk a little bit more about the public-private divide, because I think that is going to be a big subject for discussion in the next 4 years, about large private companies being subject to different rules than public companies. But for now, if you take a company private, obviously there isn't any disclosure around employees, environment, social, or governance. And so I think you're going to have regulatory scrutiny and community scrutiny, Jill, about over things like what we call synergies. The Brits are a little bit closer and less Orwellian with redundancies, right? And those are human beings' jobs. And I know from some deal planners that some CEOs have seen attractive deals that they probably would have done in a prior era where there were cost savings, but because a lot of the cost savings were jobs, they were reluctant to do it during this period. And what I'm saying is, I think as transactional planners, you can imagine people who might say, we'll do a deal, but there have to be certain guarantees to the stakeholders because we took government assistance and because of the position. Are you under Revlon allowed to set rules of the game where you put everyone on a level playing field? Because I've always, my counterfactual, and I look at Larry, and we did the film about Revlon, is had it been very clear that the Revlon board said, Mr. Perlman and Mr. Forsman, you're on a level playing field, but you will each treat these note holders who were our stockholders 6 weeks ago, you're each going to protect the notes. We promised the independent directors would protect the notes, but it's a level playing field. You have to honor that obligation to that constituency. We just made that promise 6 weeks ago. Now it's a level playing field. I'm not sure how that case would have come out, and I'm actually quite sure that I was thinking about other things in that year rather than that. But I think now you could imagine companies feeling, because of the assistance, that they might need to do something like that. And I do think it raises some interesting issues about Delaware law, because Delaware law, as a first and foremost matter, is not about profits. It's about operating in compliance with law. And I think we've known more about the residual claimant theory, Jill, now, that the fair expectancies of legal claimants can actually be dishonored by, in a non-technical way that is really profoundly gutting to them. And so I think that is going to be a focal point for, and again, we're not just talking about the Delaware courts here, we're talking about regulation, but I think it could put some pressure around Revlon, because I could see a board saying, look, we just took this bailout money. We're open to doing what was right by our stockholders. We think a sale is in their best interest, but here are certain criteria for participating in this that protect the communities and workers who taxpayers stepped up to help. And when the taxpayers helped us get to the point where the stockholders can even profit. And so I think that's an interesting issue. I think on the private equity toehold issue, it's a more traditional fiduciary duty issue, Jill, that arises, which is when the private equity firm has a large stake like that, has continued access to management, may have a director or two. If there's a take private, what is the architecture going to be used as a deal planner to make sure that there's really competition among private equity buyers, a level playing field, and how do strategics feel that they get a look at? And so I think it's a little bit different dynamic when you have a private equity sponsor that's not winding out of its position in a sale kind of mode necessarily, but actually just got into the investment, and the next step may be, frankly, to take it private. And I don't know how those will pan out, but I just know there were enough of these investments that it seems unlikely that they were doing it just to take a 5 to 8% stake. It maybe they were, and just being willing to buy at a time when everybody was beat up and to just take the ride up. But it seems likely to me that some of them may have a longer term plan in place. And I think that's going to be a little bit different dynamic than we've seen. Because we knew during what I call the cappuccino era, which was the frothy era of 2006 and 2007, that there were some situations where management met, its favorite private equity person at the grill room, and they got happy, and they, had the management team say, we can't work with anyone else. And that caused some problems, and that got right-sized. And largely there's been better practices, but it is a little bit different when the private equity toehold already exists, and when there may be someone in the boardroom, and when they're actually working very closely with management, it's natural for them to develop relationships in others. And so I think that's another thing out of this particular unique era that people ought to be watching for, that could be manifesting itself in cases. And I think it's something for deal planners you really have to manage for. And I think if you're representing a board that took these kind of subsidies, a board that got one of these toeholds, it's probably now to have, discussions about the protocols that you want to use if the private equity firm, if there's a consideration of it going private, that the board hears first, that management can't be signing up agreements and have to make it available, that kind of good hygiene. And I think on the public subsidy side, I would actually encourage you to have your boards look at least 5 years back at what forms of public subsidy you may have gotten, and to consider that dynamic and the fair expectancies that may give rise to. Because, I also think we're in a different regulatory environment, Jill, right? Where, people sometimes use regulation sideways. It's not something we want to have happen. But you can imagine that being some really fierce regulatory heat if a plant is closed in a merger situation after the target company received an awful lot of government assistance.
Yeah, I like the way you separated these two strands of Revlon. As you know, I've for a long time argued that Revlon is not an obligation, or doesn't impose an obligation to focus on, short-term profit or stock price maximization at the exclusion of stakeholder interests. So I like the idea of distinguishing sort of the stakeholder aspect of the case from the equal treatment or discrimination part of the case. But what I want to push you on just a little bit is what I hear from practice is that, practitioners and boards view Revlon quite differently. And so do you really think that somebody's going to be able to go to a board and say, look, fair conditions for workers or limiting plant closings, as long as we put that condition on all possible buyers, we're going to be okay under Revlon?
I mean, I don't know whether they're going to be willing to do it. I do think it's it's sufficiently distinct from the original case that I think you could do it in good faith. I think the overbroad way that the decision was rationalized makes it, there's clearly tension, because it basically says, once you decide to sell, stakeholder interests go out the window. I mean, it literally says that. And what I'm saying is, what if a company says, well, then we're just not going to sell? We'll sell in a way that's good for stockholders, but only if we honor the fair expectancies of our workers and communities. I think, and the countervailing thing is that we won't do this deal because, Jill, you're right. People are scared of institutional investors, are scared of the court. But, ultimately it's the buyer who runs the real risk in a real Revlon case, not the phony ones we get after closing where the 95% of stockholders voted for the deal and people just seek some disclosure or something. In the real Revlon case, where some other buyer feels like it's jilted or something, it's going to be the buyer that loses the deal because of it to another buyer or something. And I think there are also going to be some target boards to say, frankly, reputationally, we're just not going to do this right now. And I think there are going to be some buyers who actually are sensitive to this. So I don't know. And we have you mentioned short term, our memories in the US aren't very long. And so it may be that we'll go into full, robust, go for hell bent for leather for premiums. I just think there's still going to be some real sensitivity around worker issues. It's going to be a long time before most people get vaccinated. And there's been a really profound disparity between how the financial part of the economy has fared and the people who go to work in the businesses that have kept us operating, the essential workers. And so I think it's something to keep an eye on. And I think it is doctrinally presents a little bit different situation than the way the case was teed up, originally. And it'll be interesting also to see what's asked of different types of buyers, strategic versus private equity, because I think you find that many private equity complexes are quite focused now on social responsibility. They understand the Klieg lights under which their industry is operating. And they also understand that they want to bring companies, if they bring them public, they're going to have to survive public scrutiny and be ready. So I think there's increasingly a number of private equity buyers that are more sensitive to these things, Jill, and may not find those kind of requirements inhibiting. And there are some strategics who still kind of need to get it in line. There's another development that's with this, just to keep an eye on, is with the growth of private equity. Practitioners really need to keep in mind, and boards need to keep in mind, that the old divide they did between strategics and private equity, and one class needs management and the other doesn't, it just doesn't work that simply anymore. And there are plenty of private equity buyers who may not need management, and some who do. And making sure that you're setting up a process that accounts for that potential conflict of interest, Jill, I think is really important. And I think the old simple, we assume there's a conflict with private equity. We assume there's, because they'll love management and keep them. And there may not be a conflict with strategic because they'll get rid of them. I don't think it's that simple anymore.
I think that's absolutely right. And maybe to bring in sort of a third possible conflict and move us a little bit to our next topic. What about controlling stockholders and controlling stockholder conflicts? One of the things that you and I have talked about is MFW and kind of MFW creep. And I think you see a little bit of the same thing in the controlling stockholder area, the assumption that every situation in which there's a controlling stockholder involved implicates sort of our conflict of interest analysis. We now have this great sort of cleansing procedure. We can use the MFW procedure, but is there a risk that companies are going to be called upon in situations well beyond the deal or the freeze out context to use that procedure?
I have to say that I thought, and it was a period of doctrinal development that took my entire period of time on the Court of Chancery for it to ripen, because we're referring to the Conn v. Lynch problem, which suggested that even in a going private merger, there was this idea that somehow the stockholders are so scared of the controller that even a majority of the minority vote plus a special committee is not enough, and that you always have to have a judicial review of fairness, and at most you get this entire fairness light. And so, of course, when you do that, it's like, why am I going to give such power to the independent stockholders by doing a majority of the minority if I'm not getting any credit for it, anything extra for the special committee? So it took a long time to move toward it. And, in a few moves that I was involved in, what I hit upon was, well, wait a minute, if we can replicate, if the idea is that going privates, and this is where I thought, and I knew that people like Justice Jacobs and Chancellor Allen thought, if this was a special situation where, and I coined, not because I agree with this theory, I don't agree with this theory about this inherent coercion, but I call it the 800-pound gorilla, Jill, which is the idea of the 800-pound gorilla wants the rest of the food, that you're just going to get out of the way. And that was because this inherent coercion thing, I didn't agree with it, but I said, okay, but what if we do some of the following? What if it's that the special committee has to be able to say no, that there's a majority of the minority vote, that there can't be any retributive threats, all this sort of stuff. And the Supreme Court eventually, accepts that. And it was a good path that allowed these things to go forward. Frankly, at pricing, if you look at the pricing in these kind of transactions, even before MFW, tend to be very favorable compared to third-party transactions, because you also have the appraisal risk and other things on top of it, because there's not a market checker. But then in the wake of it, instead of it being predictable, which is, you put that together, plus the restoration of the old time religion that in a third party deal, a disinterested stockholder vote that was fully informed invokes the business judgment rule. You put those together, you're thinking the suits will be around, really hinky deals, things that are have got real problems. But what's happened is, as I put it, MFW creep is this idea that if you can call someone a controlling stockholder, somehow to invoke the business judgment rule standard of review, you have to do the full MFW. Well, I mean, one, MFW didn't exist as a precedent until a few years ago. Even as decrepit as I am, I know that. And the old time religion wasn't that way. And if you look, people can denigrate all they want looking at 140, what is it, 144, Larry? Am I wrong on that one? Yeah, you can denigrate them all they want. I would tell you, if you put Walt Stapleton in a room and Charlie Richards, they would tell you, if you look at 144, those were ways that in conflict transactions, you would invoke the business judgment rule. And they didn't have both these things. They had, if you have a majority of disinterested, and they used the term disinterested, Joe, it wasn't even independent at that point, disinterested directors, or certainly a special committee, or a vote of the stockholders. Now we're having a situation where people are saying, you have to do MFW anytime a controller does a transaction with the company. And it's not business judgment rule unless you have a stockholder vote plus a special committee plus all these other things that were specifically designed for a squeeze out merger. I don't think, that's not what I was taught as the old time religion. I don't know where that comes from. And I think it's tremendously judicially intense. And I think there's another part of it that's coming about, which is Aronson was a brilliant decision, I think, in many ways, because there was this concern about structural bias, right? And too easily calling directors independent. So there's a first prong where you do the independence analysis, but the plaintiffs can still go forward, even if the board is a majority independent, if there's a particularized pleading of a breach of fiduciary duty. What's been happening is if you call someone a controller, let's just skip Aronson. Let's just not look at the board. And because we'll just basically say it's controller, and therefore somehow it's entire fairness, and we don't have to do the Aronson analysis, which strikes me as not the most disciplined approach. And I think it's also interesting to suggest that if someone's a controller in the way that you would think about that you'd have a hard time applying Aronson in a plaintiff-friendly way. If they're so dominant, it should be relatively easy to address. And you have that second prong, which was the safety valve Justice Moore talked about, which is the ability to plead in a particularized way that this transaction gives rise to a breach of fiduciary duty. It's also really odd to think MFW and all this stuff applies when Aronson itself, if you look at the facts, and again, I keep looking at my friend Larry, who knows this stuff better than anybody, but by any measure, that would have been a controlling stockholder under today's thing. We're now at points where people don't even have 10%, and they're considered a controlling stockholder. I don't know, there might be a definition of controller where somebody's got a Svengali or some other thing. But again, if that's true, if they have 8%, but everybody on the board is beholden to them, Jill, my sense is you can go through a disciplined Aronson analysis and you can show that. What I'm concerned about is if we leap to the idea that we just flip the switch and it's easy to become called a controller, and then we eliminate all gates to derivative actions. If you have an effective special committee, that's not enough. What if you have a board that's controlled and you put it specifically to a stockholder vote and they vote for it, but that's not enough? So the court's then going to come in after a specific majority of the minority vote that's fully informed and non-coerced, and the court's going to examine fairness? I just think that it may be that a solution, what I understood and many understood to be a solution to a very specific problem in Delaware, which is how to deal with going private mergers proposed by a controlling stockholder, is now swallowing up sensible approaches that were taken to managing conflicts of interest in a way that balanced well the interest of efficiency and fairness. because I'm not a fan of rent seeking and the classes of cases, as we saw during the Lynch era, classes of cases where there was no benefit to stockholders. And there was, in the sense that nothing was achieved beyond what the special committee got. And we saw that during the era of Revlon forum shopping, where the only thing was disclosures. And I don't think that's good. And I think this could contribute to that. I think it's an ongoing discussion, but I think and I think there's a lot in flux, but I think it's making it very unpredictable for transactional planners.
And it's interesting because I like the way you tied that to the sort of policing function of the demand requirement. And, if we go back to Aronson, of course, one of the things that's changed is the role and the use of 220 requests. And so that at the demand stage, right, when you're sort of trying to show the extent to which individual directors are interested or beholden or dominated, today's plaintiffs have a lot more to work with, right?
Yes, and not just from 220, but as you know, Jill, the security, in some ways, because of Delaware case law developments, there's much richer securities law information out there, securities law disclosures that also helps the plaintiff's bar. And not just in 13E3 transactions. And one of the most interesting things is, for example, why, I don't know why, I mean, it was not the old time religion too, that after a deal closed that you had 220, right? I mean, this is the new thing too, which is, okay, it used to be like, and if you read the back end of Van Gorkum, there's a whole section about disclosure. Because if the disclosures had been good, you wouldn't have the damages award. And they reviewed and said that you didn't disclose these things. There wasn't the idea of the deal closes and then you get books and records before you file a complaint. And I know there's been a lot of abuses, used to frustrate me on Chancery to no end when companies would resist legitimate books and records requests. But I think there's a tension going on now, which is I think there's a healthy use of 220 in genuine derivative cases tending not to be transactional kinds of cases where you can use 220 to get that information base, and that's a much richer pool. But I also think part of what's driving companies to be resistant to 220 is just every single situation. It doesn't matter whether your proxy said that you went to 25 strategics and 12, private equity firms over a 6-month process and it did all this kind of stuff. And there's a whole thing and there's 2 bankers' books and all that stuff's out there. You still get hit with a 220, even if there's no conflict. And so I think that's something that right now is a matter of discussion among many people in practice, because it's driving people up a wall. And because rightly, I believe the Supreme Court and Court Chancery have been rightly sensitive to changes in the way information flows. In terms of informality, if a board is operating informally, Jill, but the set of information that would have been available in 1980 or 1975 to even get under 220 or even 1995 is exponentially increased if there aren't boundaries around this stuff. And so how do you
do that though, Leo? I mean, given the breadth of 220, right?
One of the things I'm raising, and just, it sort of happened in my view, without a whole lot of explanation, and people can explain to me, is why it is that when a transaction closes and you're no longer the stockholder of that company, you necessarily remain withstanding to get books and records. I don't think that was the old view. And to file a placeholder before the deal, particularly I love the people who the institutional investor has allowed the stockholder fund to have 200 shares that they can play around with in the litigation. And they sold 95% of the shares in the deal. And it's the pension fund playing around with it, not with the actual portfolio, because the fund manager wouldn't like the deal. And then they get to have a books and records action. And all of a sudden, books and records, things like that, they cost money. And when you cost money, you create settlement value, you create a drag on the economy. And unless the utility of it is worth the candle, then it's not positive for even stockholders. And I think we saw a lot of litigation during the non-Revlon era and the pre-MFW Convy Lynch era that was not beneficial for stockholders at all. And I'm just saying that this 220 ubiquity in areas that don't involve derivative suits, Jill, and where I think both of us would say, if you look at the information base out there about deals and compare it to 25 years ago, it would be really surprising that people would need more because they're getting huge amounts. There's a very active analyst community. Frankly, ISS, I'm not a big fan necessarily of the influence of proxy advisors, but with ISS and Glass Lewis, that's also an informational forcing mechanism, as you know, Jill, because the interaction between them and the company and people in deals often produces reports and other sorts of things about the process and about what's gone down. And so, you do have to watch this, and especially if you want the Delaware Court of Chancery and the Delaware Supreme Court to be able to be there for plaintiffs and in an expedited case when it really matters, with just having every single case be subject to books and records. And, and one of the things we've seen too is some of these creepy non-substantive disclosure settlements just migrating to federal courts.
So there's a huge amount there, Leo, and you're absolutely right. But let me just try to focus you on one little piece of it, because I think you're spot on, right? The idea behind 220 was to create a vehicle for information at a time when there was a lot less information. Now there's more federally mandated disclosure. There are intermediaries like the proxy advisors. You just get a lot more information on the internet, social media, everything else. So, there clearly are 220 requests being made in situations in which there's a lot of information that's available. But that's not really a factor, I think, that courts have traditionally taken into account in analyzing 220. I suppose they could. But, how do you navigate that?
Well, no, I think the big issue is this standing issue, and it may have been sort of by default decided, but I think that the courts can manage the 220 thing well in the context of classic derivative use of 220 or private companies, Jill. I mean, this is another huge role of 220. We often forget how important things like 220 and appraisal are in protecting the rights of people who are invested in non-public companies. But I think the thing that I'm talking about is this idea that the transaction is closed. You're no longer a stockholder of this company. That they can then use books and records to plead out your complaint, as opposed as what we're talking about, using the 13E3 disclosures, using the proxy statements, and all that kind of stuff, and pleading your disclosure complaint. And that's where I think the more legitimate concern is being raised by the business community, and particularly when they're doing better. What I mean by that is, if you read most of the proxy statements, people do tend to do really pretty robust pre-signing market checks. They do tend to try to create some competition within private equity and among the strategics. They really don't have, if you go back to the 80s and you compare some of the deal protections in the 80s to the deal protections now, the deal protection package is not that robust. And so if we're doing things the right way, we have more independent directors, we are putting out more information, we're using a more robust process. Why is it that we're then being hit with sort of rent-seeking lawsuits? And that was certainly the Revlon, non-Revlon cases. And there's an aspect of that coming with the 220. And with the federal courts migrating to some of these disclosure claims, and that's just a real thing. And I think that the standing issue, again, I keep saying, Larry, I'm like, Larry, rescue me here. You kind of know the old time religion, but was it your thought that people could do 220 that way?
Larry's going to take the fifth on that, I think.
Willard versus Harworth. That's old time.
Sorry, say it again.
Willard versus Harworth. That's old time.
And what's it say?
Exactly what you said, I thought.
No, and remember, we've all known the cases around whether you can have a derivative standing, right, after a merger, right? And we have situations where we may be giving people the right to get books and records from a company against which they cannot file a derivative suit anymore. And that's a little head hurting. And since you all have to be with me, it's already head hurting enough.
We'll have to give them now the carrot for having to be with you, the second CLE word. And the second CLE word, of course, you guessed it, is supreme. So once again, supreme, that's the second CLE word. I want to leave us some time for questions, but before I get to questions, there's just one more issue that I want to sort of put on the table, and that is the resurgence of Caremark duties. So we've obviously seen the Marchand and Clovis decisions, but the question that I have, and this ties into a lot of your scholarship, Leo, is how these Caremark duties going forward may be interpreted to not just allow, but require directors to give more attention to ESG type issues, employee safety, gig workers, sexual harassment. Obviously there's a panoply of things that could fall within that umbrella. But is that a direction that you think Caremark duties could or should go in?
Yeah, I actually think, Jill, they already do. I mean, it goes back to, I think that you can only conduct lawful business by lawful means in Delaware. And one of the things that you do, you have to have a duty under Caremark to try to make sure that the company has in place policies that ensure compliance with the law. If you think about where companies rub up against society, right, that's where they rub up against their stakeholders, where they rub up against their customers because they may be making a product that has health problems to it. They rub up against their employees because there might be employee safety issues. There might be issues of sexual harassment or racial inequality. There might be environmental issues for the community in which they operate because there might be effluent or something from the plant or that affects local drinking water. Well, if you think about the law is not, people denigrate the law, but the law is fairly sensible. And I bet you those of you who represent companies are going to find that your ESG concerns, and I use the E for employees so they're not buried in the S, is if you're representing a board and you're examining where you have stakeholder issues, there's going to be a lot of overlap between where you have compliance issues. And I think boards are struggling with this. And one of the things I'd urge everybody not to do is just throw something into a sustainability committee. And what I'm saying is I think Caremark's actually a lesson. I think our dear friend, the late Bill Allen, who I miss every day, if you think about your Caremark duties and you think about ESG, you ought to be thinking about them together. You don't want to be dealing with the E and environment by having one different group of people deal with it than it does with the E and environment for Caremark, deal with the Caremark thing, and another group deal with the EESG environment. Same thing for HR issues, equality issues. You want to be integrating them. And there's a good reason for that, by the way. Attending to the bottom line of the law, if you give yourself a margin when you want to comply with the law, and that margin may push you a little bit to go beyond it and be an admirable citizen. But by attending to the law, you're making sure that you're not blinkering yourself to something that society considers important and that your narrow perspective as a board just doesn't capture. And so by focusing on the minimum bottom line, that's a basic essential of good citizenship. But then if you set higher values, and I see my friend Elizabeth Pullman on the line here, she and I have both done a lot of work in this. There's a lot of evidence that compliance programs that are infused with value and meaning, where people understand, if any of you have kids, know there's a 3-letter word that's really important. And they don't ultimately give you credit right in the moment, but they give you credit over time. And that's called WHY. Understanding why you're doing something goes a long way. And part of what I'm saying, Jill, is I think there's going to be, if you want to do this efficiently and effectively, you're going to want to integrate your Caremark and compliance things. You're going to find that there are lawsuits, and I just did an article with my friend Chris Brummer that's out this week about the connection between fiduciary duty and diversity, equity, and inclusion, that we see lawsuits right now under on diversity, equity, inclusion. We see Me Too lawsuits, and they're being brought under Caremark. That the legal boundaries and what's the right thing to do are quite closely connected. And I also think there's a lot of power in this. And one of the reasons why I've said create a workforce committee is many companies still put all their risk in audit, and and it's very difficult. Audit has a lot to do. And we had recent cases in the Court of Chancery where two companies, one of them passed go under Caremark, one of them got dismissed, but both of the companies were embarrassed, paid huge fines. Very complex situations, and they dumped it all into audit, including food and pharma safety. You have situations where boards don't have any access to the HR people, Jill. And so what I'm saying is I think there's going to be increased pressure to prognosticate. There's going to be increased regulatory pressure around your disclosures around these things. So that's disclosures. You should be looking at how you do that in a way that develops good metrics. But you want to have a committees and a management alignment around those core issues that's sensible, so that an HR committee attends to your metrics around the workforce, around things like Me Too and equality, around pay equity. And if you're a pharma company, a core industry committee that looks at how you affect your customers and stuff, and then have audit do the hard work of audit. There's going to be a lot of pressure on this. I predict the SEC is going to be accompanying the good work that Jay, another Penn grad, did at the SEC on principles-based disclosure. I think, Jill, both you and I probably believe that there's going to be some specific metrics required of companies, and that the demands around this are going to force information. It goes a little bit back to what we just said, Jill. It's going to force information out there that's going to give plaintiffs tools to bring novel suits in different areas. Particularly, we know that Caremark cases, Jill, when regulators impose fines, impose sanctions, that's what often draws out Caremark claims. And when you have regulatory scrutiny, that I think is going to get tighter, enforcement's going to get tighter, you're going to have more disclosure. I think you will find that Caremark becomes more salient, and that if you get ahead of it and really think in a business-like way about how the board and management structure should line up to address these risks, that's a good thing. And it's an international thing as well, because you're going to face the same pressures if you're in the EU or if you're in Australasia, and the investor crowd is increasingly expecting it as well. And it's coming for the private companies. And there's going to be a debate about this, about the extent of whether there's going to be ESG disclosure for big private companies. And I'm hearing from pension funds and others that they want more disclosure from their portfolio, about the portfolio companies that are held by private equity funds that they invest in. And I think there's going to be an increasing, debate about how much the private-public divide holds, Jill, and that all companies of a certain size to affect society are going to have to attend to these issues. And that will give rise to some private company Caremark disputes probably as well. And I would just finish with this. Marchand was a private company. It was not a public company, but it had a fairly diverse stockholder base. And we have more of those kinds of companies now.
Yeah, and more all the time. And you're absolutely right. There's a lot of pressure right now on the public-private company divide. And as my colleague Elizabeth Pullman has written, there's a sort of seamy underside in a lot of private company governance that, the lack of disclosure has really shielded. There are any number of topics that I could continue with, Leo, but I did sort of promise our very large and patient audience that I would leave a little time for questions. So let me invite people to use the raise hand feature in the reactions portion of your screen. If you've got a question, we'll try and take a couple of questions. Don't be shy. This is the opportunity to ask questions of Leo rather than what's been going on for however many years, Leo asking questions of you. So you should welcome the opportunity. Neela.
Hey, BCS, good to see you.
Hey, Neil.
It's been a while. Maybe I'll just I'll sort of continue on the thread you were just talking about and sort of love to get your thoughts on how you think about the fact that sort of the reason a lot of companies give for remaining private for so much longer is because they don't want the short-term scrutiny and they don't want people sort of looking at their quarterly disclosure. And how do you measure that against sort of this desire to have more disclosure?
I think it's a great question, Neela. And one of the reasons why I've been commending the Delaware Public Benefit Corporation model to some of my friends at the BRT, because I think that model gives you a little bit of a balance from that. And we've seen companies come public as PBCs this year with very favorable IPO pricing. I think if I were an institutional investor, I'd much rather a company not have dual class and be a PBC, because it doesn't put you under the thumb of someone. And the big three institutions just supported a company in converting. And so one of the appeals, I think, of that model is that it gives you a little bit of space. It does the whole Revlon discussion, as we had before, Neil, as you know, goes away because you can actually protect it. But there's a very strong safe harbor, business judgment rule harbor. So there's no damages actions. If there's a stakeholder suit, it's more like a civil rights suit, an injunctive suit. And so I look at the principal utility of that as giving companies that want to do the right thing more space, because ultimately it's conservative and your investors will, drive things. But I think it does give you a useful buffer. And what I've been astonished by is the people scared that it will they won't be accountable to anyone. Well, we don't have the stockholders. This is not 1965. You have very large investors, you have very active investors, you have lots of information, you have very globally competitive products, markets. Workers don't want to work at companies that, as you know, Neela, that can't compete because they don't have a job. And so I think that moving forward in this direction, and this is where the public-private company divide comes in. Senator Warren, actually, her bill, Accountable Capitalism Act, actually called for all companies with $1 billion more in revenues to become a PBC. And she used the Delaware model. Now, she called for a federal thing. What I suggested to her is, if you want to do that, have it be under state law. But I think there's actually some real thought being given to ways to incentivize that. But even more to your point, which is, why is it that if I'm a public company, I have to do ESG disclosure about how we treat the environment or your workers or things like that, which are not just investor issues, but if I'm a large private company, I don't. And do we want to unintentionally, if we put just more on the public companies, are we going to, create this bigger reason to go private? And so I think in this debate, I've got my eye very much on the balance between those things and a level playing field. Because I think, to be honest, the SEC disclosure regime, we piggybacked on that to have our window into the economy, but that's not the way the SEC statute's written. And so I fear that if the Senate and the Congress won't act, and the SEC just continues to regulate public companies, it'll create the perverse incentive you're talking about. I think a move towards a uniform, requirement for some attention to stakeholders at all large societally important companies and level playing field on ESG disclosures would be I call it a restoration of a sensible balance in an era where stockholder power has grown enormously while stakeholder power has gone down.
Great question, Neela. I think we have time for another question. Do we have another question out here? Larry.
People want to get a cocktail. I'd also just say, watch out for, some of the things early. I think you'll see the Department of Labor taking action relatively quickly around issues to allow institutional investors to have more room to take stakeholder accounts into concern and to align their voting interest with the focus on sustainability. So I think that will also, Neela, go along with this, because I think if the new administration doesn't focus on the role of institutional investors, for example, I've argued they need to have their own ESG disclosure requirements. They need to align their things. It's just unfair to put pressure on the companies that make real products and deliver real services and ask them to do great and good things if the investor class doesn't actually have to align its conduct. And so I think there's more sensitivity to that. And there's maybe even a hope that will bring 13D, the United States, out of the medieval era and into the robust 21st century of the rest of the OECD nations, so that there's full disclosure of derivative positions, and so that, you know, companies don't wake up with 20% of their equity in the hands of folks. So I think it's going to be a really interesting time. And Jill, one of the things I am watching is I am hoping that there will be an approach to legislating in these areas, because part of what we're really dealing with is using an outmoded legislative framework that's about current 1975, not as current as the band 1975, but like the actual year 1975, trying to use that in 2021 to govern a very different economy. And neither the SEC nor the Department of Labor or other regulators really have been given the tools that are necessary to do that. And the tendency to beat up on people in good faith working at those things and asking them to do things which they're actually not legislatively authorized to do, in my mind, is kind of ungracious. And I think there's a danger that if those agencies try to do everything, stretch their limits, that always creates legitimacy problems. And it also creates the yin and yang problem of when there's a next administration with a different view, policy just changes back. And that's not what has made our capital markets as strong as they are. There's nothing like giving the SEC some responsible authority over large private companies to require some ESG disclosure from them that's uniform is not going to hurt private companies or private equity. I think actually increases their credibility. Fixing 13D, which that will actually legitimize activists and create a better argument that they play a real role. But we'll see what happens. But
we'll see what happens with that. Yeah,
all these things are on the table. And I just want to say this: you guys had to listen a lot for me. It is great to see your faces. We all miss you. ILE is a real kind of family, and the idea that we haven't been able to get together in person is a real void. So it's a treat to at least see your boxes and for you to have the patience to listen to me for an hour. It's a special part of my life. And Jill and I and Elizabeth and Larry and Dean Ruger and Nadia, we just all want to say thank you to you for being a part of our community.
Yes, and with apologies to the people that we didn't get to, I see more hands up, but ILE does have this rule that we stop when we promise we're going to stop. So we appreciate all of you for being here and taking the time to spend with me and Leo today. And we hope to see you at future ILE events. Everybody have a drink on me and have a nice evening.
Thank you, Jill.